The Coca-Cola formula has been around since about the 1880s. There are only three people who know the full formula, and they can't fly in the same airplane at the same time. It's only written down in one place, and that's in a safe deposit box in a bank in Atlanta. However, I believe the oldest of trade secrets is the Zildjian cymbal manufacture. And the Zildjian family came from Turkey in the 1600s, had developed the ability to fuse brass to bronze to make musical cymbals. That's been passed from father to son and now from father to daughter ever since, and no one's been able to really replicate it or determine exactly what they do. There are significant numbers of trade secrets in the electronic and computer industries, source codes, methods of conducting semiconductor chips. All of those areas come under scrutiny during the course of my instruction. The practice of trade secret law is very, very active as our societies become more scientifically oriented. In fact, about 4 days ago, IBM filed an action against one of its vice presidents who had just been employed by Apple Computer on the theory that trade secrets were being misappropriated. The students should come away from the course with an understanding of how this law works. The goal is to have the student be fully capable and conversant with the law by the time he or she gets to her law firm, and if a trade secret matter is laid upon their desk, be able to deal with it. One of the issues that constantly comes up is how do you explain the difference between a trade secret and a patent? First, the patent is governed by the Patent Clause of the United States Constitution. It constitutes a governmentally granted monopoly over certain information so that only the holder can use it for a set period of years. In return for the monopoly, the holder agrees that at the end of that period of years, it will become general knowledge. On the other hand, the trade secret moves on indefinitely. It is not a monopoly. The law instead enforces the confidential relationship between the discloser and the disclosee. So someone could develop a trade secret series of trade secret information independent of the holder, and he would be free to use it because there's no monopoly granted. The course is taught from a very real-world perspective. While we do deal with theory, we tend to go more into the actual reported decisions themselves and attempt to extract what is the relevant law in the field. It is obviously a very active area right now, and it's one that I think the students will find there are more trade secret actions filed than there are patent actions filed in the United States on an annual basis.